Hi, everyone. Harry here to talk about Trump's motion to delay. Always need to specify where and when, of course, because that's his focus, maybe even singular focus in all the four criminal trials. But here he's made it in the most hospitable of the different settings, the Mar-a-Lago case before Judge Eileen Cannon. And this is actually a reply brief that means that there's already been his motion and the special counsel's response. And now it's set up for a hearing. And with Judge Cannon, certainly it will be. You can be sure by by 2029 or so. She hasn't said it, so that in and of itself is effectively adding to the delay. But here is the pitch by Trump. Wouldn't be very persuasive, it seems to me, for other folks, and other judges, but with Judge Cannon, it may well be. There are two things that he has asked for a delay. One is for the Classified Information Protection Act motion. So he has to come forward. It's a very complicated regime. It's the thing that really poses the biggest risk of inordinate delay. But he's got to come forward and make certain disclosures about what classified documents at issue. He wants to say, you can't keep them under wraps. I have to be able to use them. If the government won't reveal them, they have to be, the case has to be tailored or narrowed, et cetera. So that's, that happens in these kinds of cases, sometimes even results in the government folding up its tent and not bringing prosecutions because they don't want to compromise national security. That's just not an issue here and never has been, because there are all kinds of documents at issue, and the charges against Trump have nothing to do with the content of those documents. Rather, it's just the fact of there being national defense information, which is clear to see without delving into content. Nevertheless, there'll be certain ones where, just to make trouble, he will say, I really have to, the government has to paraphrase certain things, or things have to be revealed. Otherwise, I just can't do my defense. So that'll be a whole kind of brouhaha. Then second, he has, under the rules, a deadline for disclosing any experts that he might want to use. And here again, will he find some crazy ass expert somewhere to second his notion of the Presidential Records Act, which of course should be perfectly irrelevant, or whatever he's going to use an expert for, he has to give notice. And those deadlines have come and gone, at least as initially set, but he's moved to extend them until when? 3 weeks after the end of the New York trial. So the notion is that he can't possibly make the decision and really focus on his defense in this important case in Mar-a-Lago because he is preoccupied with being a defendant in New York. Now, I think other judges wouldn't give this really much credence. You can, he in the first day of trial, he was able to, after trial, go up to a bodega in Harlem and do a campaign stop. It doesn't take all that much to just decide with one's lawyers. It's really the lawyers who are mainly deciding it. Who are your experts? What are you going to challenge? But, and I think other judges would say, carve out a half an hour and figure this out and keep things on schedule and on time. But other judges are not Judge Cannon, and it may well be that she grants this motion. Oh, and of course, 3 weeks, right, until after the trial ends. Somehow it's something that takes hours and hours and hours of deliberation and thought, both the classified information motion and the expert motion. It's just indulgent beyond really what's reasonable, but that's one sort of description one could make of Judge Cannon in this trial to date. So it's a very serious prospect. remember, this is a cut and dry trial that could easily have gone forward or could go forward in plenty of time. Result almost certainly, well, under the facts of law, very strong case down in Florida. You have to think about who's on the jury, but a very strong case. But it's quite uncertain that it will go forward before the election under the whip hand of Judge Cannon, who, even when she rules for the government, does so with a lot of sort of antagonism of them, and takes a long time to rule, and the problems we've surfaced in previous tapes. So the pretty extreme motion, I need until 3 weeks after the end of the trial. And what are we talking about there? The beginning of summer. And that's just the deadline for me to do things that I should have done before. Tell you who my experts are going to be, tell you what pieces of paper I'm going to challenge or try to push on you not to use or paraphrase, etc. So that's a nice big 6-week extra chunk of time. We're adding to what's come before and what will come after, and all of it leaves us in a really posture of grave doubt. Because it's Judge Cannon, it wouldn't be this with another judge, whether that case will see the light of day as long as she remains on it, which of course is a whole nother question of if and when the government has a chance to try to challenge a ruling of hers and couple it with a motion to recuse. But that's the story. Basically, give us 6 more weeks just to tell you our notice on a couple things that are really straightforward and real, if not quite bureaucratic. They're strategic, but they don't take that much time to decide. But they're asking for a lot, and in Judge Cannon's courtroom, they might be granted a lot. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.